Good morning, everyone. It is 9:30, so we will go ahead and get started. My name is Annie Schlink, and I am the Events and Education Coordinator for the Iowa Grocers. Thank you all for joining us this morning. I ask that everyone remains on mute throughout the presentation so that everyone will be able to hear clearly. We will start the program with Julie Kraling, Department of Inspections and Appeals Retail Program Lead, speaking on the food code updates, and then Mark Speltz, Department of Inspections and Appeals Bureau Chief, will speak on consumable hemp. Thank you both for being here today. Afterwards, we will have time for questions and answers. If you think of a question during the presentations, type it in the chat box and I will read them to Mark and Julie during the question and answer portion. If you are calling in and have a question, please remain muted until I open the questions up to those on the phone. Julie, I will now turn it over to you.
Hi, thank you everyone for joining us today to talk about the Iowa Food Code updates that went into effect March 3rd, and then some will be going into effect the first part of March. So while I'm getting my screen ready here to share, technical difficulties here. Okay. Annie, can you see my food code screen?
Yes, it looks great.
Okay, great. Okay, so the updates to the Iowa Food Code. First of all, we mailed out postcards to all of the license holders in the state of Iowa. Those went out a couple of weeks ago, and if you received one, it was a yellow postcard. This is the front and back of the postcard. It has a QR code on it, so you can scan that QR code with your phone, and it will take you directly to the Department of Inspections and Appeals website. To access the website directly, you can go to dia.iowa.gov, and then there's on the menu, there's a part where you can get to the updated food code, or you can go to this link right here directly. We also recently sent out emails to all of the license holders as well with the same information. So if you've not received that, you can go directly to our website again and find the information with all of the things that Mark and I will be talking about today. So I'm going to start with the updates to the FDA food code. Iowa was previously regulated using the 2013 food code, and now we use the 2017 with the supplement food code. So chapter by chapter, I'll go through the updates. We do have on our website, we do have a document that goes into detail with all of the changes from the 2013 to the 2017 code. So I won't hit every single one of them with this presentation, but that document is on our website for your reference. So chapter 1 is all about the purpose and the definition of the food code. So there were two updates. They added a new definition of intact meat, and they revised the vending machine definition to include a more diverse payment method. So in chapter 2, there is a new section under Code 2101.11, the assignment of a person in charge. So this section just states that in certain types of food establishments deemed by the regulatory authority, that there does not need to be a person in charge all the time. So typically we see these in our micro markets or the unattended food establishments, which we have had that amendment in our Iowa codes for a while now, but now it's in the food code. Other additions in chapter 2 or updates in chapter 2, there's language changes in some of the codes, replaces salmonella typhi with typhoid fever, and replaces the term non-typhoidal salmonella with salmonella non-typhoidal. There's also an amendment in code 2103.11 addressing the additional duty requirement for the person in charge. to monitor temperatures. So monitoring the hot and cold holding temperatures. So that wasn't previously in there, but now it is a requirement of the person in charge. And then the certified food protection manager requirements have been updated as well. And I'm going to talk about that towards the end of my presentation when I talk about the Iowa code amendments. Oops. So also in chapter 2, code 2501.11 now states that a food establishment shall have a written procedures for employees to follow when responding to vomiting or diarrheal events. These procedures shall address specific actions that employees must take to minimize the spread of contamination. So it's been, this code has been there for a while. What's new about this code is that the procedures that each establishment has need to be written procedures. And those written procedures need to be specific to that food establishment. So when we are dealing with the written procedures, as an inspector, things that we see normally when we're out there is that people are buying a kit that was put together by someone else. And then they have instructions with them that aren't necessarily specific to that establishment. So if you have a kit that you've purchased, you'll want to make sure that you look at the written instructions that came with that kit. And if they're not specific to your facility or they won't work for your facility, you'll need to ensure that you write procedures. So the procedures need to include, things like when will you implement the cleanup plan? What cleaning supplies will you use? Who will clean up the incident? So be very specific to your facility. Chapter 2 also added a new section, code 2401.13, use of bandages, finger cots, or finger stalls, which just states that if you have a bandage on your finger or on your arms, you need to, or your hands, you need to have it covered with a glove. Chapter 3 through 7, there were minor changes throughout codes 3 through 7, and those are all addressed individually on our website in the guidance document that is the summary of changes from the 2013 to the 2017 code. Chapter 6 had no changes between the 2013 and 2017 codes. Chapter 8 also had some minor changes that are addressed in our guidance document. But the ones that we want to hit on are code 8404.11, that there is a new exception in this code that states that the regulatory authority may agree to continuing operations during an extended water or electrical outage if written operational plans have been approved by the regulatory authority, which means if you have a plan in place that you have submitted to our department or your local public health department who oversees your food inspections, and they've approved that plan, if there is an extended water or electrical outage, you would be able to either continue to operate or you would be able to open back up if you had been closed without our approval at that time, because you already have the written procedures in place. And then code 8204.11 updates the contents of a HACCP plan. So if you are an establishment that has a HACCP plan or needs a HACCP plan, the requirements for what needs to be contained in that HACCP plan have been updated. So updates in the Iowa administrative codes. Iowa Code 137F adds the definition of a stand operated by a minor. A stand operated by a minor means a stand or other facility that's operated by a person under the age of 18, at which food that is sold directly to the consumers that is not time or temperature controlled for safety, or an alcoholic beverage that operates on a temporary or occasional basis on private property with the permission of the owner of the property. So if you have a food stand that's operated by someone under the age of 18 and they're selling foods that don't require temperature control, or they're selling beverages like lemonade or water or soda, they can do that as long as the stand's set up on private property and they have permission from the property owner. This is not considered a food establishment, so it's not regulated and it's not required to be licensed. We do have some additional information on our website that goes into more detail with that. And finally, the Certified Food Protection Manager information. Iowa Code 481-31.12 has the specifics on what is the new requirement for the Certified Food Protection Manager. And I'll pull that up here. So the past several years, it has been required that each facility that is required to have a Certified Food Protection Manager employ at least one person who has that certification. The update to that is it is still only required that the food establishment employ a single Certified Food Protection Manager. And that's under this exceptions right here. The food establishment may employ a single Certified Food Protection Manager who is not present at the food establishment during all hours of operation, as long as the following requirements are met. And this is the new portion of it. The individual who is a Certified Food Protection Manager needs to have supervisory or management responsibility and the authority to direct and control food preparation and service at the food establishment. The person in charge, whether that person is the Certified Food Protection Manager or another person that is there in the facility in charge, they must demonstrate knowledge as prescribed in section 2102.11 of the 2017 Food Code with supplement, and the person in charge must demonstrate active managerial control by complying with section 2103.11, which lists out the duties of the person in charge. So you can still have one person who is a CFPM, but if that person is not there during an inspection or during any other time of the day, the person who is designated as the person in charge needs to be knowledgeable, and they need to perform the duties of the person in charge as listed in the food code. So 3A, a food establishment that upon inspection is found to be in violation of section 2102.11, which is demonstration of knowledge, or 2103.11, which is the duties of the person in charge. If they're found to be in violation of either of those sections, then the facility will have 6 months to ensure that any individual that is designated as the person in charge must be certified as a CFPM. So hopefully that makes sense, but we do have we have some guidance that has a flow chart, which lays it out a little bit different and hopefully a little simpler and easier to understand. And the flow chart starts out with the facility types that are not required to have a Certified Food Protection Manager. So if your facility meets those criteria, which is you're only selling prepackaged food, if you only sell prepackaged food, you do not need a CFPM. If it's a temporary or farmer's market food stand, it does not need to have a CFPM. If the food that's being served is not prepared, or you're only serving beverages, that's limited to ice, beverages, or prepackaged snack foods, popcorn, peanuts, or reheating commercially prepared foods like frozen pizzas or hot dogs, then you don't need to have a CFPM. And the fourth exception is a food establishment in which food is not prepared, where customers may purchase only commercially prepared, non-time or temperature controlled for safety foods that are dispensed either unpackaged or packaged and are intended for off-premise consumption. So if you meet one of those four exemptions, then no certified food protection manager is required. If your facility doesn't meet one of those four, then the flow chart says, is any person who is in charge a certified food protection manager? If the answer is yes, then you're in compliance. If the answer is no, then it goes back to, do you have at least one person, or is the person in charge knowledgeable, and are they performing the duties of the person in charge? And if the answer is yes, then you are in compliance with the certified food protection manager requirements. If the answer is no to this section, then you are required to have any individual who is designated as the person in charge become a certified food protection manager within 6 months. Newly licensed facilities must meet the CFPM requirements of the one CFPM within 6 months. And if you're a current facility and you had a CFPM or you have a CFPM and they leave employment with your facility, you have 6 months to meet that requirement again and have one person be a certified food protection manager. So there are several ways to obtain your certification. The following courses, there are 6 courses out there now that are ANSI accredited programs where you can obtain your CFPM certification. Those are all listed out on our website and on this guidance document as well. Okay. So I'll turn this over to Mark now.
Again, if anyone has questions, just put it in the chat box and then Julie will be happy to answer it after Mark's presentation. I think you're muted, Mark.
Yeah, I was trying to unmute and I was unsuccessful. So again, thanks everyone. Thank you, Julie, for covering our food code changes. And again, if you have questions related to some of those changes, we'll answer those at the end. And we do have a lot of information on our website as well. A lot of the changes that we didn't talk about are primarily editorial changes, maybe referencing different sections of the code, or maybe just some cleaning up some language for clarity. So not really making significant changes that will impact your operations on a daily basis. So we really tried to hit on the ones today that do have more of an impact to your stores. So we want to shift gears to consumable hemp. Been a very hot topic for the last couple of years, not only in Iowa, but also nationally. So I want to give you a little bit of Iowa's, a little bit of Iowa's history here over the last year with this particular product and regulations around it. So prior to 2020, it was back in 2018, the U.S. Farm Bill passed, which really allowed farmers to grow what is considered hemp. And it was a legal commodity that could be passed around, grown, harvested, crop insurance available, really distinguished between what is a, kind of an industrial hemp product and marijuana. So once they had done that, then the USDA then worked with the states to say, okay, if a state wants to grow this, you have to have a plan in place that we approve to regulate it. So then Iowa put together their plan with the Iowa Department of Agriculture to allow this product, to allow hemp to be grown in Iowa. So the next phase of this was with House File 2581, which occurred and passed last legislative session, which said, okay, now we're going to define what consumable hemp is, and then also ask the Department of Inspections and Appeals to draft rules to regulate consumable hemp products. So we have been working for over the last year, let's see, on drafting those administrative rules to execute that legislation that passed in 2020. So with this product, it really crosses a lot of different boundaries. So there was a lot of different state agencies that we worked with in order to draft a set of rules that everybody was comfortable with. We also worked with the Attorney General's office as we drafted the rules to ensure that we were following not only our own statutes and laws, but also all other statutes and laws within the state of Iowa. We also engaged some national organizations like the Association of Food and Drug Officials. We also worked with other states that are kind of in a similar place that we are, where federally there isn't a national model, there isn't a national regulation, and essentially consumable hemp products are not legal nationally. So say the dietary supplements or the gummies or all that type of stuff that contains CBD technically is not approved by the FDA and it is an illegal food additive. So, but many of the states haven't decided that they didn't want to wait for the FDA to kind of create a national model, and they started passing legislation and rules to allow for the sale within their states. There's several states that are kind of in that same kind of timeline that Iowa is. So we worked a lot with those states as we were drafting our rules as well to try and find something that was at least as close to similar as possible. So you didn't have a completely different regulation in Florida or Texas or Kentucky as you did in the state of Iowa. So that's just a little bit of a background on that. So as we talk about the legislation itself and the rules, we'll go into a little bit of detail on some of this, and our rules are posted on our website at dia.iowa.gov. There's a little section in the lower right-hand corner of the homepage that will have a link to the consumable hemp regulations, Iowa Administrative Code, Chapter 32. And then once the registration system is available, there will be a link as well for folks to begin registering as a consumable hemp establishment. So this is a very big definition that you're looking at and a lot of words on this screen. So I want to touch on a couple of key points. A consumable hemp product is essentially something that is either taken through the mouth or absorbed through the skin. So if it's a topical lotion or a cream, it's still considered a consumable hemp product. If it's a tablet or a tincture, or it's added to a beverage or something along those lines, then it's consumable hemp. A couple of things that it is not is it can't be smoked or inhaled. So smokable hemp is something that is not allowed in the state of Iowa. We break down our to a consumable hemp establishment. So when we're drafting our rules, we looked at it much like we looked at our food establishment rules. So we tried to use some of the same modeling in drafting this rule, because many of the folks that are licensed with us as food establishments will also be licensed as, or registered anyway, as a consumable hemp establishment. So a consumable hemp establishment means any individual or entity that is engaged in manufacturing, processing, packing, holding, preparing, distributing, or selling a consumable hemp product in Iowa would be a consumable hemp establishment. And that means if there's out-of-state manufacturers, out-of-state distributors, and out-of-state retailers selling product into Iowa, they would also have to register, not just the Iowa-based companies as well. So we've divided up our consumable hemp establishments into kind of two broader categories. We have the consumable hemp retailer. Those are the folks, probably what most of you might be doing if you decide to sell these types of products, is selling products directly to the consumers on a retail basis. That would include anyone selling online as well. And then we have the consumable hemp manufacturer. This would be someone that is either taking the plant and extracting it, making an ingredient that's going to later go into a product that's consumable, or making the actual consumable product itself by taking ingredients that contain consumable hemp and mixing or manipulating or processing. It also includes a facility that may just be distributing. So like a warehouse where they have a bunch of consumable hemp products and then they're distributing out to convenience stores, grocery stores, or other retailers that might be carrying it. One thing that it does exclude is the distribution of raw hemp. And I guess I'll get to that here in a little bit. But our definition in our administrative rules talks about what is processing. So it's a long definition. And again, it's something that is really modeled after the food regulations, because many of these folks, especially the manufacturers that are manufacturing, they will not only have to comply with the hemp rules, but if it's a product that's going to be taken in through the mouth or consumed, they'll also have to comply with all the food regulations. A little bit different if they're making a topical or a lotion or a cream only, where it's not ingested, then there wouldn't be that same requirement because it's not a food. But anything taken through the mouth or ingested in Iowa really meets the definition of a food, and they would have to comply with both sets. So we stayed, again, consistent with our definitions on food manufacturing related to and applied that to hemp as well. What is excluded from regulation as a consumable hemp establishment is someone that's really just dealing with raw hemp, so a raw agricultural commodity. So maybe if you translate that to the grain bins or the corn and soybeans that we grow here in Iowa and other commodities, if it is just the plant material that has been harvested from the field, and then it's transported or moved from one place to another, that wouldn't fall under the consumable hemp regulations. Now, certainly there would still be regulations under Iowa Code Chapter 204 that the Department of Agriculture administers for growing and transportation of hemp, the hemp plants, but it wouldn't fall into the category of a consumable hemp product if it's really just that raw agricultural commodity. Now, whoever takes that raw agricultural commodity and does something with it, they will be a consumable hemp manufacturer. So now we'll kind of switch gears and talk about registration. So who's required to register? So all retailers and manufacturers of consumable hemp are required to register. They cannot sell or distribute products in Iowa until they are registered, have an approved registration by the Department of Inspections and Appeals. We are hoping that our registration system is actually up and active here in the next couple of weeks to allow people to pre-register for the earliest approval of a registration would be on March 3rd. It will be an online registration, and the registration fee is set at $475 annually. That is a number that we had to do some estimating to kind of guess how many consumable hemp establishments we might expect to register in the first year. If that is lower or higher on the registration number, this fee could be adjusted each year to kind of balance that, because we were directed to charge a registration fee to cover the cost of processing our registration. So that's where that number came from. We may have facilities that are doing both manufacturing and retailing of consumable hemp. So if that's the case, a manufacturer, they would have to register as a consumable hemp manufacturer and a consumable hemp retailer, two separate registrations for those activities. There is one exception that we put in there though. We know that we have a lot of small cottage operations or small farms that might want to grow it, manufacture it, and process it into their own line of products, and they're exclusively going to be selling their own line of products, and they might try and wholesale it and get it into one of the a store or to a retailer, but they also might be selling online directly to consumers. In that case, if they're only retailing to consumer customers the products that they manufacture exclusively, then they wouldn't need the retailer license. Their manufacturing license would cover it. But if all of a sudden they decided, oh, well, I'm not only going to sell my products, but I found some products from the state of Washington or from the next farm over, and I want to start selling some of their products in my line as well, that means then they would need to have that retailer registration. Package and labeling. Part of the statute that passed, the legislation that passed, directed us to establish labeling requirements for consumable hemp as well. And this is something we did work a lot with other states and seeing what they were doing, took feedback from them and also from the industry folks. Again, we didn't want to have a labeling requirement that was so different from another state that it would cause some concerns with products coming into the state. So what we did is we tried to be very consistent with what they were doing nationally. So this is what we have right now. So all consumable hemp products need to have a lot number, an expiration date, and the product name, information about the manufacturer. If there are specific cannabinoids contained or marketed for the product, the label must contain the number of milligrams per serving and serving size. They also must have a certificate of analysis to show that the hemp, that it is hemp, that it's below 0.3% THC. Again, anything above 0.3% THC would still be considered a controlled substance in Iowa. There is some degree of plus or minus there, and that is something that's covered in Iowa Code Chapter 204 as far as what that kind of threshold for accuracy is on that test. But 0.3% is the dividing line between what is hemp and what is marijuana. In addition, some of these labels are going to be probably not very large. And if anyone has seen what a certificate of analysis looks like, it could be pretty large as well. So the second part of this is not all of this information has to be contained on the physical label that the bottle or container or package has on it. But there does need to be links to that information. So what a lot of the industry is doing with the consumable hemp products is they will have a QR code or a URL or a scannable barcode on that package label that folks can scan and be taken directly to the site to view that certificate of analysis or information about the manufacturer as well. We all know in the food labeling world that it may say manufactured for or distributed by, and we really need the information about who actually manufactured it. And that is partially because of the way the law is written in Iowa, that consumable hemp's only allowed from states that have approved plans, and not all states do. So there might be some restrictions on where that product can come in, and that's a piece that we need to confirm on our end. Certificates of analysis. So what are they? Essentially it's a document that's prepared by an independent laboratory. It ensures that each batch has been tested by that independent accredited laboratory, testing for the presence of concentrations of cannabinoids, testing for THC, and also testing to ensure that the product doesn't contain harmful levels of pesticides, residual solvents, metals, pathogens, or other toxicants. Those limits and specific toxicants and pathogens and metals and solvents are all listed out in the rule itself. So that will help folks guide to work with their laboratories to ensure that they're getting everything tested that they need to. Product documentation is also something that not only manufacturers need to have, but retailers will need to be able to supply as well. And one thing I did talk about is that where that product comes from. So that jurisdiction of origin. Since the products that are allowed to be sold in the state of Iowa can only come from states that have an approved plan by USDA, approved hemp plan by USDA, it does exclude some states, and it also excludes all foreign countries. The USDA does not approve hemp plans for Canada, Mexico, or other nations. So the products that come here into Iowa that are going to be sold in Iowa have to be U.S. manufactured and may only come from states that have approved plans. So in addition to the labeling information, we need to make sure that each retailer and each manufacturer has documentation that shows where that product came from. So the brand, if the documentation also needs to include not only where it came from and the manufacturer, but also the brand name, the container size, lot number, and then the certificate of analysis. What other laws and regulations would apply to consumable hemp manufacturers? So again, as I stated before, that anything that's consumed or not, consumed could be absorbed through the skin, but if it's ingested through the mouth, they're also going to have to comply with food regulations on the manufacturing side. As a retailer, many of you, most of you are all licensed with us anyway, and if you would treat it like any other food product that you have. Mostly you're probably going to see these products in, I don't know if it's going to be in the, the pharmacy areas or some of those other areas within your stores. But again, you must ensure that those products are labeled appropriately according to the regulations when you receive them, and that you maintain that jurisdiction of origin documentation. But you'll also have to continue to comply with the food code requirements as well. For a manufacturer, it'll be depending on what they're manufacturing. If they're manufacturing something that is a food, then they need to comply with the food regulations. If they're manufacturing something like a topical lotion or something along those lines, then that same requirement would not be in place. Other laws that are impacted here, potentially have impact here. We have alcoholic beverages, meat and poultry, and dairy. Those three areas, we worked with those agencies when writing the rules, drafting the rules. They were pretty clear that within their own state, within their own laws that they have for those agencies, that this product, hemp, could not go into alcoholic beverages, meat or poultry, or dairy during the manufacturing process. That does change a little bit as there are some allowances for retail, primarily for restaurant type service, where maybe you're adding it to an alcoholic beverage or a beverage or milk or a milkshake or something like that, or at the retail level, there is some allowance for that we'll talk about later. But as far as, if a distillery or a brewery wants to add this to their beer during a manufacturing process, that would be prohibited by the alcoholic beverages division. Some other prohibitions placed out. So the sales are limited to only not allowed on the premise of a residence, except if they have a separate area for it. This is similar to how we do our food regulations as well. We often have caterers that operate out of their homes, but they build on either a separate kitchen or have separate spaces. We also have a lot of folks that maybe have storage. They sell frozen meat at the farmer's market, but they also have a warehouse where they store their frozen meat on their farm. It has to be completely separate from any living space. So if a residence is able to separate that, they could sell from the home. It's limited where the consumable hemp cannot be sold on the premise of a temporary location. So like a food stand, roadside stand, temporary booth or structure. That's really all about traceability. If we happen to find someone becomes ill or finds a product that contains some contaminants that it shouldn't, we need to be able to trace that back not only to the retailer, but also to that manufacturer, and may need to work to get that product removed from the market. With limited door-to-door sales for the same reason, and vending machines also kind of for the same reason. One other thing with vending machines is that although in Iowa there isn't an age restriction on who can buy consumable hemp, there certainly is in other states. So we know that there's been conversations about that here in Iowa as well. So we really want to be cautious as we're moving forward. We wouldn't want to have a vending machine operator invest thousands of dollars into machines and then a year later not be able to do them because you can't restrict age on a vending machine. So, and then also at private parties, if you think about the Pampered Chef and some of those other Tupperware type parties, if Tupperware is still a thing. So we just wanted to be very, very cautious and as we move forward. Some of these restrictions or limitations or prohibitions, I guess, could be lifted at some point. But I think we just really want to enter this market and with our regulation in a very cautious manner and not put people at risk. Farmers markets, however, there is an allowance to sell those products at a farmer's market stand with some exceptions. And I'll talk a little bit about why that is. Farmers markets, we have a pretty strong relationship with. We know that those markets, we know the market masters. They also are, those markets are registered with the Department of Agriculture. So we have contact points where if a product was sold at a market, we would be able to trace that back to the retailer that sold it because the market would have record. So there's a lot more, there is traceability when it relates to farmers market food stands. The stand itself is no different than the one that would be a temporary booth or roadside stand. It might be the same exact stand, but because it's at the farmer's market, there's a little more ability for us to trace back potentially contaminated products or harmful products that might get out into the market. So it is allowed there, provided that the market's registered with the Department of Agriculture. The individual selling it has a consumable hemp registration that's valid. The consumable hemp registration is posted in plain sight at the stand, and all the products have been listed with the department that they're selling. I told you we would talk a little bit about the food service kind of exemption. So what this is that a consumable hemp retailer cannot manipulate a product. If you have those products that you're going to sell, you have to sell them in their original containers. You can't buy bulk and repackage into smaller containers and put them in baggies or do anything like that. That would fall into manufacturing. You can't process, prepare, or do anything at the retail level that would be considered manufacturing. Now, if you want to be a manufacturer, you could then get a manufacturing registration as well and follow those regulations, and that might be possible if that's the direction you want to go. But as a retail registered hemp facility, you wouldn't be able to do any manipulation of that product, with one exception, and that is, again, a food service establishment. So if you have restaurants or food service within your stores and you want to add this to meals or beverages or ingredient that are going to be immediately served to a customer. So if you think about, shakes are at a bar, if you order a milkshake and you want to add that to it, you can do that as long as it's for immediate service, but you couldn't make a batch of it and store it. It would have to be something that would be intended for immediate consumption. And that retail store, that restaurant type sale in the restaurant itself would still need to disclose all of that labeling information to the consumer. I know similarly we've seen consumer advisories that are used on placards and table tents. It might be a similar way there. It might also be on a menu with a scannable code that links to the product. I think there's a lot of creative ways that the retail industry can provide that information when there is not a label. You'll have the master label on the container that you're using, and you'll have to make sure that that information is accessible to that customer without them having to request it. It needs to be available to them. And one other thing I want to point out and highlight is that the first arrow here, a consumable hemp label and any associated marketing material shall not contain any claims that a consumable hemp product can be used in the diagnosis, cure, mitigation, treatment, prevention of disease, or is intended to affect the structure function of any body. So I know we've seen a lot, you've probably seen them as well. I know that I have. There are some of these products that are out there that make some pretty outrageous claims. So if they're making those types of claims, they are considered a drug and not a food or a consumable hemp product. And until they're until they are an approved drug by the FDA, they can't make those claims. So I will tell you that the FDA, although this consumable hemp is not legal nationally, the FDA is not taking a lot of action on consumable hemp manufacturers that are following the rules, that they're not making these claims. But those that are, they are making claims like this. The FDA is taking action on those firms that are making some of those claims. So I do know that. So you'll want to be careful as the retailer that you're reviewing the products that you're bringing in and ensuring that those claims are not being made. Essentially, those are, again, drug claims that have not been approved. And it's not only illegal federally, it's also illegal in Iowa. The Iowa Board of Pharmacy has the same language in their law as well. And it refers to, essentially, unless it's an FDA approved drug, you can't make those claims. So I want to reinforce that. And again, that's going to fall on the retailer to ensure those products don't have that. You shouldn't be carrying it if it does. So where are we at with consumable hemp? So we published in the rules, the draft rules, and had them open for public comment in November. We reviewed those public comments. We made some necessary changes. And then we resubmitted our proposed, adopted, and filed rules to the Administrative Rules Committee. And today is our last Administrative Rules Committee hearing, unless there are changes that we need to make based on that committee's feedback. If everything goes smoothly today, which we anticipate that it will, we feel we've done a really comprehensive and a good job. The rules will go into effect on March 3rd. That's when they'll be effective. And again, we're working on getting that registration system up and running. We hope to have that registration system available ahead of March 3rd, so it will allow us to start reviewing registration applications, so we can start approving many of those on March 3rd. And until you have that approved registration in hand, you cannot sell these products. Okay, I've been talking a lot, so let's open it up to questions for both sides.
Mark, the question I have for you, someone asked, would there be a different process for a warehouse?
So a warehouse is essentially a distributor. You know, if they're going to warehouse that product, so I guess it depends on where the product's being sold. So I think of warehouses in a couple of different ways, but primarily I think of a warehouse where I'm going to store products and then I'm going to distribute to retailers that are then going to sell the product. That warehouse, that location, must be registered as a consumable hemp establishment. If those products are ingested, then they also need to have a food processing plant license in the state of Iowa. So they would need both. If it's only the cosmetic kind of stuff, the topicals and the lotions, they would need to be a consumable hemp manufacturer, registered as a consumable hemp manufacturer, but wouldn't need the food license. If they were exclusively retailing products from a warehouse, so if I'm thinking about maybe a residence that builds a warehouse on their farm or something along those lines, and then they're only selling online, then they could do a consumable hemp or retail registration. Hopefully that helps.
That is the only question we have in the chat, so I will open it up to phone calls. If you would like to unmute yourself and ask a question, you may do so now. We also just got a question, can retailers deliver this product after a customer purchases online or have a third-party delivery company deliver?
Okay, that's a really good question and one that I have not thought of. So I will research that back and I'll get back to you, Annie, and maybe help get that information out there as far as that delivery mechanism. I want to think through it first.
Does anyone else have questions today? Okay, Julie, this is for you. If our CFPM that has supervisory control leaves, but we have been required to have all PICs certified, do we still have 6 months for the supervisor?
If the certified food protection manager leaves employment, you have 6 months to replace that person as the CFPM. Yes.
Any other last minute questions? Otherwise, we can end a few minutes early today. And if you think of any, go ahead.
I have a question that was sent direct to me, and I'll see if Mark has an answer to this because I've never been asked this question. And that question was, what if the certified food protection manager is on medical leave?
So and we didn't account for different types of leave or different types of situations. And I think the clear answer is that if you were required to have one manager that has management and supervisory authority, and that one person is on an extended leave, I guess the question becomes, how do they have management and supervisory authority to direct and control food service operations? So it may depend on the extent of the leave. If it happens to be for a couple of weeks, like a normal vacation, I think in that case, you wouldn't need to replace that person or get a new certified food protection manager. But if it's something that's an extended leave, I don't know how you're gonna, that individual is gonna have management and supervisory authority and the ability to direct and control food service operations. So if you wanna, I think you need to have someone there that has that to meet the requirement. So I don't know if there's a hard cut line between, is it 2 weeks, is it 3 weeks, is it a month? But I think that's the determining factor as to whether that individual has control or ability to direct control. So I think it depends on the extent of the leave. And I think on those individual cases, we can work directly with the inspectors and the supervisors to kind of identify based on individual circumstances what that means.
And if anyone thinks of a question after the webinar today, you can just email me and I can reach out to Mark and Julie to get that answer for you. But if there are no more questions, we can go ahead and wrap up. Thanks again, Julie and Mark, for being here and giving your presentations. I think it's really helped everyone a lot. And thanks everyone else for joining us this morning.
Thank you, everyone. I appreciate the opportunity to talk in front of you.
Have a great day, guys. Thank you.